it's time.
Commissioner Goldthorpe, it's now 5 o'clock.
All right, then, thanks everybody for showing up for this very special work session that Mr. Steve Price is going to talk to us about our protocols and procedures as commissions. Take it away, Steve.
Thank you, Mr. President. For the record, Steve Price, ACHD General Counsel. Today I've been asked by the Director and the President of the Commission to provide a information briefing on ACHD Board of Commissioners protocols and procedures. I take great pride in this presentation. It's one of the few times that I can tell the Commission what they can and can't do. And generally they don't listen anyway, so we're okay. Just kind of a little bit of a background. Thank you. These protocols were developed a number of years ago, and it was developed by the Commission, and they're really designed to create some goalposts, if you will, on Commissioner conduct. And throughout this, I've also embedded some other statutory requirements that are within the protocols themselves. First off, this is a provision within the Title 40, Chapter 13, which involves highway districts and commissioners. And really the whole point of this is that commissioners are considered employees of the district. And if you recall, to the new commissioners, I emphasized that on your initial briefing. And that's relevant because all employees are liable and responsible for the actions. The district is liable for all of the actions of the commissioners and employees as they're performing their duties on behalf of the district. You all took this oath of office or something similar. What it means is that you've taken an oath to follow the laws of the United States, Idaho, and the ordinances of ACHD. Again, the protocols originally developed to avoid conflicts and entanglements over commission business, and back in the day we had a lot of it, and this has helped. These were adopted through a resolution, and they're binding on the commission, and they can only be enforced by members of the commission. And I have provided copies of the actual protocols to you, both in your initial briefing as well as the residing commissioners. The most recent amendment to the protocols occurred on March 16, 2011 through Resolution 980, and they can be amended by the Commission at any time. This is kind of just a summary of how the protocols are set up. They talk about meetings, rules of conduct, quasi-judicial proceedings, public meetings, how they're addressing the Commission, public hearings, policy-making decisions, administrative support, communications, and some miscellaneous provisions regarding standard of conduct. Now, the key point on the public meetings is that, as you know, we're governed by the Idaho Open Meeting Law. The district, we have, like most local governments, we have public meetings and we have public hearings, and there's a distinction. The regular meetings that you hold are just public meetings where we discuss numerous matters, are discussed and decided, and we have action items. And the open meeting law now requires us to disclose when the commission's going to take an action. We also have public hearings, and these are required by separate Idaho statutes, and they require specific procedure and additional notice, usually 60 to 90 day advance public notice. It's usually a portion of our commission meeting regular agenda, and the commission is acting in a legislative decision, not a quasi-judicial decision-making process. We're going to get into that, and it's often an area of confusion. In our meetings, we have agenda presentations, we have public communications, and we have miscellaneous matters, usually director report or admin report. Key points within the meetings, kind of rules of conduct. Commissioners will limit his or his comments to the subject matter item or motion being considered by the commission. Commissioners in the past have gone off and talked about all kinds of different things that aren't really relevant to the item before them. And the commission, through their resolution, have kind of tied their hands to this. Commissioners will govern themselves to the length of their comments or presentations. Tie votes means in a lost motion. Sometimes we only have 4 commissioners. It'll be a 2-2, and it means if you have a tie, then the motion dies. If you're silent in the voting, then it means yes. Serial meetings, we've had problems with these in the past. These are meetings that at any one time, there's a whole bunch of people that are involved in a series of different discussions, but eventually will involve a quorum. So for instance, Commissioner A, you have an agenda item that's before the commission. It's going to be required to have a quorum and a vote. Instead of discussing it when it's before the commission, you have a phone call between Commissioner A, Commissioner Z, Commissioner E, and F, or the director. You can't do that. You have to have any discussions on an item when you're assembled in a quorum. Serial meetings yield a process which deprives the public the opportunity for a meaningful contribution to the decision-making process. And I always advocate for always err on the side of public input. Expartate Communications. No doubt you will have these. And this is when a commissioner's been contacted on a subject matter that's going to be as a basis for a quasi-judicial matter. I'm going to get into that in a minute. Before the commission, let's just say a development project. You get a neighbor or the developer and they call you. Well, in those instances, you're required to disclose the details of the communication for the public record and the nature of the communications. Commissioners must indicate whether the ex parte communication was made and provide a written statement as to the substance of the communication. And also, I did include that because of the communication that you can remain to be fair and impartial in making a decision. This happens a lot. You can ask Commissioner Goldthorpe. Generally, the advice is when you feel like an ex parte communication is coming, just direct them to write to the commission with their thoughts, not really get into any of the specifics.
And if you feel like somebody's trying to set you up, arrange the meeting in our general counsel's office, which drives him nuts.
Well, since will be driving me nuts, the City of Boise had a land use application a number of years ago, and it was revealed in the record that the council had had discussions with members of the public and the developer, and they failed to disclose it. It went up on appeal, and the decision of the council was reversed.
Dang.
So it's a big deal. So now we're going to get into quasi-judicial or legislative. And as commissioners, you sit in 2 different capacities, and in a meeting you can sit in 2 different capacities. A commissioner, when you have in a legislative capacity, you can have communications outside the open meeting, requirements to discuss legislative issues. If a commissioner does, though, we still like to, just as part of being transparent, we like the commissioner to disclose any communications with the public or third party. Quasi-judicial, again, you're constrained by ex parte communications. And just so you know, in a quasi-judicial setting, a commission must, all of their decisions must be confined to the record that's before the commission. The idea is the commission should be making decision on the same set of facts. If you talk to somebody, you're going to have different facts in your head. There are cases in Idaho that even prohibit commissioners from going on site on a development application and then come in and make a decision on it. If you want to do something like that, we can arrange it, or typically the director in the past has had staff go out and make a video and present it to the commission at the time, so that the public and the commission have the same set of facts.
Steve, can I ask a question?
Sure.
Mr. President, if I may. Back on the legislative action category, I can imagine cases where there are issues that the commission is deciding, not a particular case, but acting as a legislative body, where there's a lot of public interest, and I could imagine a commissioner getting a lot of contacts from members of the public about that particular issue. The comment there, or the notes there that say to disclose any communications with any of those communications, would it not be reasonable to foresee that there could be instances where that would be impractical?
Yes.
And so, if I've had 20 or 30 phone calls from members of the public about such and such, it would seem adequate to me and perfectly reasonable in that situation to simply disclose that I had a lot of public input.
Yes.
And, most of them said X, others said Y, and leave it at that.
No, that's the right practice. The other practice is to encourage them to send in written comment to the district, to the whole entire board, so that they get the same information.
All right. Thank you.
Okay, finally, we get into quasi-judicial and legislative. When you're sitting and you're acting in a legislative capacity, you're adopting an ordinance, resolution, or other policy, that is a legislative action. So any rule, standard, you're going to be acting like the legislature. You'll be making law. And then in quasi-judicial, which is typically relates to a private property right, like development, the commission's required to make a finding based upon the evidentiary record that has to be confined, the same record each one of you gets to see. So you sit as a judge and jury and required to make findings based upon evidence in the record presented, no outside facts. You have to apply those specific facts of the matter to the standards provided in our policies that are adopted. And again, those are examples relating to parcels of land, access, variances, and staff decisions. Any questions on that? And we typically, the president of the commission, they will identify whether it's legislative or quasi-judicial as the item pops up.
Or sometime in advance of the meeting when you call Steve.
Yeah, and anytime you have a question, well, certainly feel free to call me. But once you'll get the hang of it, it's pretty clear. You'll look at the agendas a lot differently.
Yep.
And you'll go down and you'll go, oh, legislative, oh, quasi-judicial. Now, staff does a great job in helping with the evidentiary record. And that's really their function. And then the public meetings and the discussions from the public, that also goes into the record. And Stacy's the one that administers and keeps that record as secretary of the commission. So in a quasi-judicial proceeding, you have a duty to find facts from all the evidence in the record. Again, you have to follow the law, which you've taken an oath to do. You must not be influenced by personal likes, bias, dislikes, opinions, prejudices, retribution, or sympathies. Now, there's going to be times when there's going to be people that you've dealt with that have come to the commission before that you ended up not liking. I promise. And the next time they come, you're going to feel that level of dislike. But you really have to resist that temptation and really consider the application on the merits, not on the person.
Steve? And I'm going back on my own experience here with quasi-judicial matters that I had far less understanding of than I wanted to going into a commission meeting or hearing. And so I approached you and was able to meet with you and other staff members and still stay within the law. Is that still correct?
Yes, there's going to be instances where your common knowledge, I mean, that's why we have a commission, is you have common experiences and backgrounds, and that isn't relevant. I mean, it is relevant. It's very relevant to actually your decision-making process, but it is not illegal to rely upon that. It's not illegal for you to say, you know, I've driven this road 100 times in 30 years, and, you know, I experienced X, Y, or Z. That's just common practice. What we don't want is for you to go out of your way when you have a quasi-judicial proceeding to go in search of making factual findings. Common experience and knowledge is okay. Thank you for that clarification.
Well, I was just thinking of the time we spent together and with staff during the St. Luke's development agreement and all that stuff, because I needed help.
A little bit just came up, but yeah, thanks for that time
You're
travel. Again, there's on specific facts, policy determinations have to be based upon written findings of fact and conclusions of law. When you look at staff reports, that's what those are. They identify the law, which is our policy, and it makes factual findings about what the application provides. Much of the testimony that comes in will somehow be encompassed within the findings of fact. Staff recognizes when we receive public comment, and we're pretty good usually on the findings of fact at that time. If the commission takes an action that differs from the staff recommendation, then this commission has to make an individualized findings of fact and conclusions of law. And so what happens is once you do that, you'll say, well, I don't agree with the staff report because of this testimony, these documents, and it doesn't meet our policy. Staff has to get that, and that's fine. Staff has to get that, include that in an amended staff report, and then we submit that to the land use agency. Just as a reminder for, and I talked about this earlier with Commissioner McKinney and Commissioner Pickering, that our policies regarding exactions, they meet all of those tests and over time. So those are, when we require improvements, we require conditions, those are exactions, and those are based upon findings of fact and conclusions of law. Now, we'll get into this in the next presentation to you next week on the development review process, how ACHD interfaces with our land use partners. But this is the one statutory provision that ACHD has sole authority over, and this is subdivision plats. And your responsibility is to make sure that when a plat is submitted to the highway district, that you consider, when considering for acceptance of approval, you do that as to the continuity of highway pattern, widths, drainage provisions, right-of-way construction standards, traffic flow, traffic volume demand occasionally by the proposed subdivision, either within or without the boundaries of the proposed subdivision, or other matters pertaining to the function of the highway district. So, you know, really the plat has identified roads on it, and we are really accepting, at the end of the day, we're accepting those roads into our system for maintenance. That's what's going on, and these are the things that we look at, and these are what our policies focus on. I had covered this also earlier on regulatory taking. It's to ensure land use policies and decisions don't violate private property just one of the key things is that if it's found that we're in a taking, then we may end up having to pay attorney's fees and costs, as it may be an inverse condemnation or a regulatory taking.
I'm sorry, Steve, just to go back, just for clarification, could you define specifically what is meant when we say inverse condemnation?
Yeah, well, so you have two different types of condemnation. You have the good old garden variety that a right-of-way department does, and that's the exercise of the power of eminent domain or condemnation, where we go in and take property for our roads. That's the first kind. The more complex kind is inverse condemnation, and that is a regulatory taking. That through one of our regulations, one of our policies, it acts as a taking. It deprives somebody of a property right. There's different types of regulatory taking. There can be right on its face, a regulatory taking that requires something that's beyond what the law would allow. You can have something as applied, where you can have a policy that on its face it isn't a regulatory taking, but as it is applied to a particular case, it could result in an inverse condemnation. Another form of inverse condemnation is where we go and build a road project on somebody else's property, and we don't establish a property right to be able to do that. And that results in an inverse condemnation. That's the kind where we were supposed to go get eminent domain. Sometimes we'll have a survey that's off. We'll accidentally build on their land. We're subject to an inverse condemnation. We're most certainly governed by both the substantive and procedural due process guarantees that are afforded under the 14th or the 5th and 14th Amendment. And this is an area that's ripe for developers to sue the district, and so much of the process that we have in terms of how we allow the public to speak and the developer to present, and we make sure that we give them adequate process so that everybody gets a fair shake at expressing their concerns. And when in doubt, again, I always say more public input is better. It protects us, and it's fundamentally sound within the procedural and substantive due process requirements under the law. We're also governed by the Equal Protection Clause. No state shall deny any person within its jurisdiction the equal protection of the laws. And this gets into areas where local government bodies make arbitrary and capricious decisions. So let me give you just an example. Developer A comes in and he has 100 lots, and we make him build 100-foot of roads and put in sidewalks and bike lanes and the standard policy stuff. We have developer B come in 4 months later with something very similar, if not similar, and we impose different conditions upon that. That would be a violation of the Equal Protection Clause. We have to treat everybody the same. Now, typically, you're going to have some developers really good, they're good lawyers come in, and they're going to try and argue with you that we're treating their client different than we've treated other clients. And that gets back to the importance of the written findings of fact and conclusions of law, because those written findings of fact and conclusions of law need to make those distinctions so that the decision isn't arbitrary and capricious, and that we afford people those equal protections. This too will come up. Now, this is if in my private practice, I had sued a governmental entity under what they call a 1983 action. And this is a developer favorite provision to go after the personal liability of elected officials. And this provision is under the Civil Rights Act, and it is so that it protects a person from local government, that their deprivation of any rights, privileges, immunities that are secured by the Constitution. So the idea is they come in and they say, well, you messed with my development, you're not allowing me to develop my private property the way I am, and you've deprived me of my rights, private property rights. That's the argument. We won't let it get to that. But you need to be aware of it. It really doesn't create a substantive right, because those are guaranteed by the Constitution, but it provides a remedy when a governmental entity deprives those rights. It again creates personal liability to elected officials. There's no immunity under the Auto Tort Claim Act, and they're entitled to attorney's fees and costs, compensatory damages. They can get intangible psychological injuries, financial property, physical harms, punitive damages, reckless or callous indifference. And you're probably wondering, well, how does this apply to us? Well, I'll tell you about the case that I had. It was the development of a big light industrial facility, and the Elmore County Commissioners were caught in a meeting saying that there's no way that they would let a person of color develop anything in their county. And that's what we're talking about, is that kind of egregious conduct. It can result in treble damages, which is 3 times the amount of the compensatory damages. And a lot of the evidence issues are what elected officials say on social media, emails, witnesses to oral conversations. I don't think we've ever had a 1983 action at the Highway District. But again, we just want to make you aware of that it exists.
I'm remembering, Steve, when you were explaining this to us the first or second time, you indicated that the word malice was pretty important. If we were showing malice in our decision-making process, personally, we could...
Well, that's why I brought up retribution.
Yeah.
In the commission policy decision-making process, when it's a legislative, in developing our policies, rules, regulations, we're limited by our statutory purpose. Now, cities, a little while ago I talked about the Dillon Rule and the Home Rule, and within the Dillon Rule, cities have their powers within the Constitution, some of their powers. They have general police powers. It makes them a general purpose government. And they get to use those powers to the extent to protect the health and welfare of the community. So they have a lot broader authority than ACHD. We're a special purpose government. We can only do what's within our enabling legislation, roads. I wish we could do more, but we can't. And so when we're developing policy in a legislative action, we have to, whatever we're going to pass has to follow our statutory purpose. Also, when we're making policy, it's important commissioners participate in community activities, that they talk to their constituents, that they get input about ways to change what we do, how to make us better. We have work sessions. A lot of commissioners have ideas. They ask staff to provide work sessions on topics, and we do a lot of new business, and we have a lot of new ideas, and it's worked very effectively. And then there's a policy decision-making process that's in the appendix to the protocols that gives a general guideline, but that's how we make policy. Any commissioner can recommend to the commission to consider a new policy at any time.
Steve, I have a question on this. When we're talking about legislative actions, the standard rule of thumb for any legislative body is that they're entitled to do anything, generally speaking, so long as they have a rational basis for doing it. That same standard still applies to the actions we take, so long as they're within the sphere of our statutory authority. Is that correct?
Perfect.
Okay.
Section within the protocols provides guidance on mail, commission correspondence, clerical support, the calendar, requests for research or information, salary, expense reimbursement, mileage reimbursement, travel expense reimbursement. Those are all things that Stacy and the director's office generally can help you with or get help for you. But anytime you want to refer to any of those, they're in the protocol manual. Media coverage, communications. Really, the communication department should be involved prior to any communications with the media. That way, as a body, at least 3 commissioners have decided what the message would be for the district. You're going to get requests for an interview. We also ask that you work with the communication department to do that. The request will generally be given to you through the communications department. You're going to get controversial or sensitive communication requests, so it's important that we get a handle on it. The president is the official spokesperson for the commission. That's why he fights so hard for it this year. If any commissioner communicates with the media independent of the board, they should always make sure that it's not the official position of the board, unless it is. Again, as you know, the open meeting law requires for a lawful meeting we have to have a quorum. And we changed the law a number of years ago now that we allow meetings to be conducted by telecommunication devices, including Zoom. And the only person that's present, that needs to be present for that situation would be the director in the building. Exempt public records. The Idaho Public Records Act has numerous exemptions that apply to the district, and no one within the district has the authority to disclose that without the commission approval. We've never had a request. Confidential or privileged communications. Those are the information that we discuss in executive session shall not be disclosed to a third party without prior commission approval. Attorney-client work product exchanged between ACH attorneys and the commission shall not be disclosed to any third party without prior commission approval. I don't have the authority. The director doesn't have the authority. Only the majority of the commission has authority to waive any privileged communication or work product. Individual commissioners are prohibited from disclosing that, again, without authorization. Now, the final area of the protocols relates to standard of conduct. And first, it provides that each commissioner shall adhere their conduct to the highest standards of professional and moral conduct. And then it lists several different areas. Each commissioner shall comply with the protocols, comply with the district's code of ethics, which will give you training in the future, which is really Idaho ethics for state and local officials. Comply and enforce the district's adopted personnel policy, including equal employment policy and our sexual and other harassment policy. You won't treat any commissioner's employees in an abusive and unprofessional manner. Not willfully or knowingly circulate, publish, or exhibit any false statement or presentation concerning ACHD commissioners' employees. Not willfully neglect or fail to perform faithfully a duty imposed by law. Not act in an arbitrary and capricious manner. Not commit an unlawful act. Not act inconsistent with his or her official duties and won't violate her or his oath of office. Any commissioner who violates these standard of conducts may be punished as prescribed under state and federal law, including forfeiture of his or her elected office, the communication may adopt a public censure statement admonishing any violation of the standards of conduct. I've never had it happen in my almost 20 years. Had a couple that were close, but we never got there. Additional standards of conduct. Again, since you are employees, you are governed by our employee handbook. And like all employees, they're expected to discharge their responsibility faithfully, willingly, and to maintain courteous, friendly, and cooperative attitude towards fellow employees and the general public. An employee is prohibited from engaging in any conduct that could reflect unfavorably upon district service and must avoid any action that might result in or create an impression of using public office for private gain, giving preferential treatment to any person, or losing impartiality in the conduct of ACHD business. And in any violation of those, you're going to also have an ethics issue. Just as a prelude to our presentation on ethics, ACHD has adopted really the highest levels of ethical conduct, and we do that through meeting the statutory requirements through ethics. But then we have a doctrine that's called an appearance of fairness doctrine, that even though it may not be a true ethics violation, that the appearance of your involvement may rise to the level of giving people the perception that you're not able to be fair and impartial. At the end of the day, ethics is really about public trust. And the whole basis of ACHD and other government entities is that we need the public to trust what we do. And if we do anything, and generally if we do one thing that's wrong, like the city of Boise experienced in 2003 and 4 with Mayor Coles, then the public loses confidence. And it only takes one thing, and it takes years to recover from. It takes, I think, 15 positive things to get rid of one negative thing. And so we're very, very sensitive about maintaining our public trust and our adherence to the highest levels of ethical conduct. Our ethics are also to protect the integrity and operation of ACHD, and we prevent special interests from unduly influencing government action. We have, $130 million budget. We've got a lot of vendors that are trying to influence the district to give them the business. They're trying to give you special treats and favors and trips and meals and all of that. And what are they trying to do? They're not looking for friends. They're trying to unduly influence you at the district to give some government action that benefits them. We'll get into this more on the ethics presentation. More in terms of the parameters of the public censure, if there is a violation of the commission protocols, the commission has to adopt a public censure statement admonishing any violation, reprimanding the commissioner publicly for the inappropriate conduct. The decision to adopt the public censure must comply with the Idaho open meeting law and must also be requested through a motion by a commissioner. The motion should be based upon sufficient factual support for the commissioner's consideration, for the commission's consideration, and the use of the public censure is an extreme measure and should be used with due caution. Enough already. Enough of that doom and gloom stuff. Let's get to work. Do you have any questions or concerns?
Mr. President.
Steve?
Yes, sir.
So I just have one comment or question. I know it's come up in the past. I get nervous about when even a seemingly simple question like, hey, do you think this person is good to put on the such and such advisory committee goes out by email, and then we sort of think, oh, well, that's no big deal. Sure, reappointer. That actually is a deliberation, and we shouldn't be deliberating by email. So is there some way, and to clarify when those are just like little things that are not very important, and those where we shouldn't be deliberating, because obviously that's outside of an open meeting, even though it's not a big deal.
Well, again, the selection of members to a citizen advisory committee is a legislative decision. You don't have the same parameters that you do with quasi-judicial. If you get those kind of requests, we ask that you have that person send that in to all of the commissioners, or you send it in and say, this has been a recommendation. But we most certainly, if you would like, we can provide future guidance on those type of administrative, fuzzy deals, if you will. But that falls within the legislative decision-making area.
Mr. President?
Yes.
Thanks, Mr. Price, for the presentation. I'm looking forward to the additional work sessions. I think just looking forward to the next ones. The more examples, the better when it comes to the ethics violations, and what does it look like when a commissioner just kind of pushes the edge on retribution and acting out against a particular project or proposal, and when do they get a pass? I would just be more curious about the type of language that commissioners have used in the past that hasn't justified an ethics violation.
Well, hopefully we have a new commission, but you can almost see it in a commissioner's face when it happens, and it can get argumentative, and I'm sure you've probably witnessed it in the past. So I'm certainly happy to come up with more situations. They're so unique to those specific circumstances, but we look forward to just a commission that treats everybody in an open and fair manner, treats them with respect, and doesn't take any of those things into account. It's actually pretty easy. And it's also pretty easy to let yourself go over the line, but you always have to pull yourself back as to, all right, this is what's before me. This is what I've got to make a decision on. I'll give you one quick example. We had an attorney a number of years ago, a very reputable land use attorney, came in here and over a very controversial development application and blatantly lied to the commission. Wasn't even a close call. And the commission knew it. And you could see the hackles get up in that situation. And thank goodness that the commission, they recognized it, but at the time, they still made the decision on the facts and our policies. So those are the type of things that will get you riled up in front of the commission, but really caution you, there's really, always take the high road. But I will try and come up with more instances. I'll have to go back through some past agendas.
Mr. President, may I ask one additional question?
Yes, you bet.
Steve, this is kind of I suppose it's a hypothetical, but it's something that's worth considering, at least I think. There are, in business generally in the U.S. today and also in government circles, there are sometimes what you might call politically charged workplace trends. I'm thinking, for example, of one thing that was an issue most recently, what they call critical race theory, being used for employee training in various workplaces. And of course, I don't know, some time ago, under the Trump administration, that was nixed in federal employees, and then most recently this week, President Biden reinstated it. I have my personal views about that particular theory and about the sort of the tests that are used to employ it. So here's my question. As members of the commission, for example, if a workplace has requirements that all employees undergo such training, theoretically, I presume that an employee who refuses to do it, that could be considered grounds for their dismissal. At the same time, as commissioners, while we're employees of ACHD, we weren't directly hired by ACHD, but instead answer to the voters. And so I've thought to myself, I've wondered that and imagined that the situation could arise where a workplace trend of that sort is imposed upon employees, and you have members of a commission like this who are not exactly excited about it. That raises an ethical issue, and maybe it's one that's too hypothetical to answer now, but suppose you had a situation where someone on the commission refused to be involved with workplace training that the district might decide to introduce. What would be that? What would happen in that sort of situation?
Fair question, Mr. President and Commissioner McKinney. You are right. HR department's not going to be calling you and trying to terminate you. What they will do is they will note for your file that you refused that training, and that's it. We can't require it. Typically the training that we've done in the past for our employees is pretty run-of-the-mill, generic, standard blueprint, black letter law. We don't get into implicit bias. We have in the past, we stopped that. So if you see anything like that coming, I would raise that concern with the director prior to the time that we do it, and then we could have that discussion with the commission as a whole. If the commission decides to go through with it in a majority, then we most certainly would just note it in your file. That's how we would deal with it.
Okay, thank you. Appreciate the answer.
With that, Mr. President, my
Yes.
presentation's concluded, and I'm exhausted from the number of questions that I've received,
You poor guy.
and I've enjoyed having to tell you what you can and can't do.
I'm sure you did. Thank you very much.
You're welcome.
Well, it's time to begin our pre-commission, so we will. In looking over the agenda for today's meeting, do any of the commissioners have any questions?
Mr. President, I just have a quick question
Yes.
on item 5, which is great. I'm really excited about it. I think it's so cool that we are moving forward with freeing up money and accelerating other projects. So my question mostly is, are there other projects in the pipeline sort of nearing that, so that the next set of funds, and if so, what are they, so that we sort of know what might be coming, as it were, potentially down the pike? And I know we're getting up to a deadline. It's like, the year is on us already, but I guess that's my question.
Sure, and I anticipated it, I guess, because I asked the same question of the director before the meeting, and he'll give you the answer that we talked about.
Mr. President, Commissioner Hanson, the answer is yes, we're watching that very closely. Yes, we will have an update for the commission. And yes, we are reviewing top to bottom all of those projects. We think it's important with the just for day-to-day operations, but the same token, as we briefed you last time with the governor's initiative on transportation funding, one of the operational goals we have is to ensure that we are well positioned to spend any extra dollars that may come our way, and these projects that are on the shelf are excellent candidates. So yes to all.
Great. I just wanted, this is fantastic. This particular neighborhood where these sidewalks are going to be built has actually were highlighted in some research that the city of Boise did last summer, showing some concerning health indicators. And one of many factors was the connectivity and the safety that people felt. And so it's so cool that we're helping to address those sooner rather than later.
We aims to please. And I also mentioned to the director about the additional projects on that list of gap projects we started creating 2 years ago that we're too expensive to fund at that time. So those will be brought back up as well. Okay, if there are no,
Mr. President?
yes,
Before we go on from this item, this is the one item that also jumped out at me from the consent agenda. I'm wondering if I could get a little bit more background on these two projects and this sort of general category of things in general. You know, what was it that freed up the funds? You know, is this a particular category of projects that only apply to community projects, or does it apply to other capital improvement projects? Can you give me a little more background on this? Because I was a little bit.
Mr. President, Commissioner McKinney, yes, I can. I want to be very clear, and I've said this many times with our staff. There are no freed up funds at this point. The Commission's resolution was very clear in that we would look at end of project final payouts, and at that point, we would see that the funds were available or not, and present that to the Commission for their determination on what type of community programs, safe walks, safe sidewalks, school projects, all these different things that we can then add to the huge list that we have already. So we have made, we have a very aggressive budget committee that reviews everything we do on a weekly basis. And so we believe that we are very comfortable at this point knowing what we think we know, that these two projects, which have been on the shelf for some time, they're very important to the communities. We can move forward now because they're ready to go. We just have to put them out to billing. We have a list of those, and I'll be more than happy to sit down with you and walk you through those priorities and the Commission's direction to us as to what type of projects we should be looking for.
So this resolution 2328, this was a resolution from the prior commission.
That is
session.
correct. Yes, sir.
And available bid savings, was that the difference between budgeted amounts and
Budget
actual
and
bid?
final payout.
Okay,
So this could be something where it takes us 2 years, 3 years, 2 months, depending upon the capital project, a very
Okay.
specific category, that the commission wanted to, if we could, flag those funds and then put them into all the great community projects that we have, that our cities have asked us to do. And at the end of the day, through the integrated 5-year work plan and the budget process, you know, there's this much money and we have this much stuff. This is a way of answering those
okay.
questions.
And so these were projects that the information indicated they were like, you know, 90% or 100% designed,
Yes,
on the shelf, ready to go.
Yes.
How many other projects do we have that kind of fall into that category?
I'll have to
roughly?
get back to you, sir. I don't have that in front of me right now.
All right.
one other thing, Dave, is that soon, I imagine, or expect, soon we'll be having an Excel spreadsheet that will show us those projects that have come in under our estimate. And we can track those so that we'll know when to expect that we'll be doing this again and again and again, hopefully.
Okay.
And Mr. President, Commissioners, about 2 weeks ago, 3 weeks ago, I did brief you on that list and such. I believe there's 10 on it. More than happy to keep you posted. But I want to, again, caution the Commission that these are projected.
Sure.
And you never know what's going to happen until that final bill is paid. We might wind up owing $1.25, or we might be getting $1.25 back.
I understand.
If I can, just
Yeah.
make up one. Just kind of as follow-up for our new commissioners, the Budget Committee, they will, next month and in the summer, we come out with quarterly budget adjustments that takes all of these ebb and flows in project costs and expenses and revenues into consideration. And we come to the commission at those times and say, we got more money, this is what we're proposing, how to reallocate those. We anticipate that as part of that in the future, that these projects and this additional money will be disclosed, but no decisions will be made unless it's independent in a circumstance before the commission, but it generally be taken up during the budget.
Right. Thank you.
And if I'm not mistaken, Commissioners, you'll be seeing that, Stacy, next week? Next week.
Okay, very good.
Excellent.
Now for the director's report.
You want more? No, Commissioners, a couple things to share with you. First off, it's my honor to let you know that I have reappointed Lisa Brady, the chair of the Bicycle Advisory Committee, in accordance with the bylaws that have been established. I don't know if Lisa's on the call or not. Okay, she was not able to make it, but she's doing a great job, and I look forward to her continued leadership with the Bicycle Advisory Committee. Talking about work sessions, I'd like to share with you, and we'll get this, as a matter of fact, I think they're already on your schedules, or on the commission schedules going forward, but here's what we have planned for you in the upcoming weeks. Next week, on 3 February, you'll have our lobbyist legislative update to you, and you'll also have a discussion, again, that's right, from the General Counsel, on funding and development plans review. So you have an idea of where we get things, how things are spent, and the rules of engagement when it comes down to your roles there. The following week, on 10 February, we have a work session scheduled on the master street map, livable street guide, and the complete streets policy from Plans and Projects. They'll walk you top to bottom on these very important documents. And then again, to be followed by the world's greatest general counsel and HR, the law. It'll be riveting and such. On 17 February, we have two pretty large work sessions. How do we determine speed limits? I think that's an important, and Commissioner Goldthorpe, you will not be teaching that one, even though you are a graduate of the Road Master and Road Scholar program, I'm sorry. And then the integrated 5-year work plan update as to where we are. On 3 March, we scheduled you for a commission request, a work session on overhead street sign names and on mast arms. How do we look at bigger street signs, what the issues are and such for your review. On the 17th of March, we have a work session on ACHG lighting standards and requirements to assure you what we can do and what the rules of engagement are for us as a transportation highway district. And then on 7 April, we have speed mitigation and traffic calming presentation as a work session as to what we do and why we do it. And we are working on something a little different. There's still more work to do on this, but for those of you that attended the most recent PAG Advisory Committee, there was a member of our committee that made a statement, and the statement was that I should pay attention to something they were going to say very carefully, and I believe they included the other commissioners on that, and that was a discussion on vertical elements, on how that might help in the reduction of speed operations. We're seeing if we can get that in front of you from that individual to brief you on those concepts. That's more on that later. And then on the 31st of March, we will be presenting a work session on your request for us to review the specific 5 lanes to 3 lane potentials in the CIP, and the second one will be the bike and pedestrian performance measures update. So as you can see, you will have a very busy February and March and into April, and those are just the ones that I'm adding. They aren't the ones that are already on the agenda for you. So we'll work your schedule very carefully on those. You also heard, most likely, that there's been President Biden has directed the OSHA to get involved with COVID-19 policies. I want to assure you all that we have taken our standards and actions are well above anything that has come out of the federal government at this point in time. We're in a wait-and-see perspective, see how this rolls in. Of course, we are not officially under OSHA requirements, but as a good business practice, we do follow those requirements, but we are well in advance with those. The President also announced that they are looking at raising on federal operations the minimum wage to $15. Now, historically, Idaho has gone along with what, as we do today, what the minimum wage standards are. We are looking at potential impacts that would be to the Ada County Highway District and, of course, our contractors and project managers. We'll keep you posted on that, but that may have an impact. And then, of course, the other initiative that the President signed under executive order was to strengthen the Buy American policy. We are well within that However, again, that may be an issue of increased costs. We don't know yet, but we'll keep you posted on that, but we are looking into it. And then finally, I want to share with you, as you know, last year we deferred chip sealing operations due to the COVID-19, and our tremendous maintenance team then focused on the huge backlog of work things and requirements that had been running for some time. I'm proud to let you know that we completed, of the 192 projects that were on backlog, we completed 177 of them for a 92% completion rate, which is absolutely tremendous. We have deferred a couple of them, I think 12, into this year to continue to work. So we have got a great handle on that, and you'll get a formal presentation later on the specifics of where, when, and how. So with that, Commissioners, that's my administrative update for today. I stand for any questions you might have.
Are there any?
Mr. President, it's now 6 o'clock.
Seeing none,
Mr.
we
President,
yes?
Mr. President, I just want to thank the director. Earlier, I sent him a list of the 6 federal aid capital maintenance projects in my side of town that I've talked to our neighborhoods about, just sort of figuring out whether there might be something that could be added to those. It's going to be extremely difficult, but I don't know whether that is or isn't, and I need to go back to those neighborhoods and say what might be possible and share also with staff what the neighborhoods are thinking. So I appreciate the director setting up a meeting with Justin and whoever else so we can kind of explore these. 3 of them are in one neighborhood. So I really appreciate that. I think if there is some wiggle room on 1 or 2 of them, that might be good. But perhaps even better is that in understanding what the neighborhood's concerns are, we may be able to do the maintenance work in order to preserve future design and construction of what the neighborhood needs in the future years. So we're not making it more difficult to sort of, or everybody sort of understands what's coming down the pike in the same area. And we can explain why, in fact, we have to go in and do construction in the same area 2 or 3 years in a row. So I really just appreciate the director getting back to me. And then if there are changes, we'll bring them to the commission, but if not, we'll take it from there.
Okay, thank you very much. Ladies and gentlemen, we will go ahead and begin our commission meeting by standing and reciting the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. With that, I would entertain a motion to accept the agenda.
I'll move to accept the agenda.
Is there a second?
Second.
All in favor? Aye.
Aye.
All right.
Any opposed? Then we'll go into the consent agenda. And the consent agenda items on it are considered to be routine and are enacted with one motion. There will be no separate discussion on these items unless a commissioner or citizen so requests, in which case the item will be removed from the consent agenda and placed on the regular agenda. And all consent agenda items are commission action items unless otherwise noted. Are there any requests to move anything off the consent agenda? That being the case, I would ask for a motion to approve the consent agenda.
So moved.
Is there a second?
Second.
All in favor?
Second. Oh, go ahead.
Hi, Mary.
Aye.
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 Thank you.
Aye.
Well, now we will go into the regular agenda, which there are no items. So the final item on our agenda are public communications, and I would ask Stacy if anyone has asked to address the commission.
I do not have anybody, but I was just looking to see if anybody was going to raise their hand. But I think
Okay.
we are good.
Then I declare this meeting adjourned. Thank you for being here.
You know,